Hello, everyone. Welcome to the first Sanderson Firm webinar of 2025. Our webinar today is New Year, New Changes to MSA Processes and Section 111 Civil Money Penalties, What to Know and How to Be Prepared. We're going to go ahead and get started. We've got a great panel today. While I do have two outstanding attorneys here, including myself, we're going to try and make this not too legalese for you. We want to make sure that everyone understands these significant updates that have come down from CMS in just the past couple of months or so. We're going to make sure that you take away some good best practices for your organization. I'm going to toss it over to Annie Davidson, who's recently joined Sanderson Firm this year. Annie, please introduce yourself.
Good afternoon, everyone. Like Heather said, my name is Annie Davidson. I'm an attorney, and I'm super excited to be over here. My background is in MSP compliance, and I'm currently serving as the president of the National MSP Network, so you may see me around a bit, but super excited to be working with Heather and Brendan and all of the great folks at Sanderson, and excited to be part of the first webinar of this year. Brendan?
Thanks, Annie. So hello, everyone. Good afternoon, good morning from wherever you are listening from today. My name is Brendan D'Souza. I am the Chief Legal Officer here at Sanderson Firm. And just quickly, a little bit about myself. I started in the Medicare secondary payer space in about 2018, where I was an associate attorney at a national provider of MSP services. And there really was thrown into all aspects of MSP compliance, Medicare conditional payments, Section 11 reporting and auditing, and also drafting and review of the accuracy of Medicare set-aside reports. So happy to be here today to join you all.
Well, I'm Heather Sanderson. I'm the founder and chief executive officer of Sanderson Firm. Been in the industry nearly 20 years. We're in our 5th year of business here at Sanderson Firm. We are a woman-owned business. We have a nationwide footprint. We provide Medicare secondary payer compliance services nationwide. And I'll talk a bit more about our services later in the presentation, but we're really excited to be here today and that you're looking to us for thought leadership in this very important area. With that, let's go ahead and get started. So our agenda for today, we're going to talk about some recent updates and the new administration for 2025, both the new actual administration at the executive level, as well as its impact to the Centers for Medicare and Medicaid Services, as well as some changes within the MSP personnel at CMS. We're going to talk about the revised MSA reference guide and some changes there, particularly that Medicare is no longer going to review Medicare set-aside allocations that are zero as of July 17, 2025. We also had another update, which we'll talk about later in the presentation, which is now that amended review on a CMS determination is now immediately available. You don't need to wait the 1 year. So we'll talk a bit about that. That'll be available in April. We've talked about this before, but we want to make sure to go over it again. The mandatory MSA reporting that is going to be required as of April 4th, 2025, just a few months away. Certainly a significant update that we want to make sure you are all prepared for. Then we're just going to kind of take a brief look back in time and look at MSA history and imagining how CMS may challenge MSA amounts. To our knowledge, Medicare's never challenged a non-submit MSA in the past, and some have questioned, well, is that Medicare's intent with now collecting the MSA information through the Section 11 reporting? Are they going to be challenging MSA? So we're going to talk about, if that does happen, what the process would look like and really dig into that. We're going to talk about civil money penalties and the final rule and what that means for your organization and registration of an RREs, as far as making sure you have timely, compliant reporting. And just briefly, we're going to talk about our educational programs that we have going on through MSP College. All right, Brendan, please take it away with the recent updates on the thresholds.
All right, everyone, we're going to start with some recent updates. I'll call this the quick hitter section, so we'll get through these in about 60 to 90 seconds for each one. So recent updates. The first one, CMS on December 16th of last year, they published their annual update to the Section 111 and recovery threshold. So for I believe it's the 9th year in a row, the threshold remains at $750. So what this means is if you have a claim, a workers' compensation claim, where ongoing responsibility for medicals are not otherwise being accepted, or a no-fault claim again, where ongoing responsibility for medicals are not otherwise being accepted, and a physical trauma liability claim. So one of those claims, which involves a Medicare beneficiary, and the total settlement amount is $750 or less. If it meets all those criteria, then that settlement, not only does that settlement not need to be reported to CMS, but CMS actually will not seek conditional payment recovery because CMS has just essentially determined that these are de minimis or nominal settlements, such that even though the claim involves a Medicare beneficiary, there are no MSP reporting conditional payment or any sort of obligations there. Real quick note, there is an exception for general liability claims that involve ingestation, exposure, and implantation. So let's say you have a work comp claim where the person has an alleged asbestos injury. If that claim were to settle for, let's say, $100, that claim was accepted, right? So that claim would need to be reported to CMS, and CMS would still have an interest in that settlement. So, okay, so quick update number 2. So just last week, there was a federal court decision out of Illinois. This case involved an insolvency fund. This was a case where a Medicare beneficiary suffered a compensable workplace injury that was covered under their workers' compensation insurance, but the work comp insurance carrier actually went out of business. They were insolvent. And so all states across the country have these insolvency insurers or insurers of last resort to protect policyholders in instances where the original carrier is just no longer is in a position to pay out these claims. So this Medicare beneficiary had a compensable claim, right? Medicare made payments for that beneficiary's injuries. And so Medicare, when they went to go seek about $13,000 in conditional payments, they couldn't go after the original carrier. So they instead said, okay, look, we can't go after carrier one. We're going to go after this Illinois Insurance Guarantee Fund, who is now involved. And this guarantee fund said, hey, look, we're not responsible for any of this. The Medicare Secondary Payer Act doesn't even apply to us. And the specific legal argument that they made was that they were not a primary payer, as that term is defined under the Medicare Secondary Payer Act. And the court actually ended up agreeing with them because this insolvency insurer did not write insurance, did not collect premiums, they didn't insure against any risk. So they were not a primary payer, as that term is actually defined under the MSP Act. So the insolvency fund handled this case correctly. We've seen plenty of cases where there is an insolvency carrier involved, and rather than go through Medicare's administrative process, so your level 1 contractor appeal, your level 2 QIC, or qualified independent contractor appeal, sometimes these insolvency funds skip all of that and they want to go directly to federal court to make their claim. Law is very clear that you have to exhaust all of your administrative remedies before pursuing a remedy in federal court. So this fund handled it correctly. If you want more information on this, I'm giving a very high-level view. Please visit our blog, sandersoncomp.com/blog, for more information on this case.
Perfect. Well, thank you, Brendan. Yeah, new case law, and then of course wrapping up 2024 with the latest and greatest in the recovery and reporting thresholds. So the big news here, of course, we're hearing all about, as Heather said, kind of the new administration, right? The Trump administration has taken over again. He's back in office. And with that comes the changes. We don't yet have Health and Human Services Secretary sworn in yet, nor do we have a head of CMS. So keep an eye on what's going on in the Senate. I think I saw RFK Jr. did advance today along party lines. It looks like he would be the head of HHS. And then what's been rumored is Dr. Mehmet Oz would be the head of the Centers for Medicare and Medicaid Services. So those are the political positions. We don't have more information on that. You're in the know just as much as we are. We're watching that in Washington, D.C. What we do know is there's been some changes at the administration level with the folks that we deal with. For those of you who have been doing this a while, like we have, you may be familiar with the name Steve Forey. Steve Forey was the person who was the acting director of the Medicare Secondary Payer Unit. He retired on January 10th. So he is living life in retirement, working on some home projects, I think is what he said to those of us who talked with him at the MSP network before he retired. With that, you may also recognize the next name I'm going to talk about, Jackie Sippa. She is now promoted to his role. She's the acting director of the Medicare secondary payer area. We know her, we're familiar with her. She's a lot like Steve. So we're hoping things kind of cruise along in the way that we've come to know and expect. As you may have heard in the media, the Trump administration did impose a communications freeze that was supposed to have maybe been lifted as of yesterday, and CMS was directly impacted by that. So I did speak with Jackie Sippa about that in my role as MSPN president, and she confirmed they were part of the freeze. She was working on figuring out what they might be able to say to the public and when, and be able to participate in sessions and things like that. But she said, you know, this is to be expected with any change of administration. So more to come on when we will be able to talk with CMS kind of more openly about ideas or see them at conferences. The other big news, for those of you who do Medicare set-asides, you will recognize the name John Jenkins. He, for the last about 10 years, was overseeing the Medicare, the WCRC, the Workers' Compensation Review Contractor, and their overall contract. And he actually has taken a different position within the federal government, doing something else. And so Cynthia Gross is taking over. She will be overseeing the MSA program and that contractor. So that's where we're at right now. Cynthia Gross did have the position before John Jenkins took it. And for many of us who've been doing this a while, things were a lot quieter and maybe a little bit less interesting when John wasn't in that role. So we'll have to see how Cynthia does and if it's a really good partnership with her and the MSA program. So that's the new administration update there for you. And we'll move on to the next slide here. We've got the new reference guide that just came out. It's version 4.2, and it was released January 17th. It's got some goodies in there. So it just came out, as you already heard Heather mention. We're going to see the review of legal and medical zeros fall by the wayside. CMS is no longer going to review them. That does not mean that they fall by the wayside. Those products can and do still exist, and we will talk more about them later. The next bullet point, though, is that the amended review criteria has expanded, and as of April 7th, there will no longer be a 1-year waiting period to send your case back for that one extra bite at the apple. And we'll talk about that here as well. But that's super exciting. That's something, if you attend any of the MSPN conferences, I've certainly been lobbying for that hardcore, and they listened. At the conference last year, I had heard C40 saying maybe they would dial it back to 6 months. So super pleased that there's really not going to be any waiting period, but watch for more in our webinar.
Okay, so $0 MSAs. So the first substantive area that we'll talk about, obviously later in this presentation, we'll talk about zero MSAs being phased out. But for now, let's sort of lay the groundwork and give you a little bit of history on zero MSAs, where they came from, the history, and where they're going. So what is a zero MSA? Well, like the name implies, it is a Medicare set-aside where nothing is being set aside for future medicals. So the Medicare set-aside amount is zero. So generally speaking, you can think of these as two different types of $0 MSAs. The first one would be a medical zero. So this would be a scenario where the medical records confirm that the individual will no longer need claim-related Medicare-covered future medical care. So typically we see this as a statement from that person's treating physician confirming that, to a reasonable degree of medical certainty, this individual will no longer require medical care. So that's like a medical zero. We also have legal zeros where, sure, the person may actually, is injured and may actually need medical care, but the employer and the carrier is not legally responsible under state law to pay for that individual's claim-related Medicare-covered care. So we typically see this in situations where, for example, maybe there's a statute of limitations argument, and let's say it's a work comp claim and the injured worker waited 10 years to file their claim. So sure, the person is still injured and they need medical care, but under that state law, the employer or the carrier is not responsible for funding an MSA. And so in that case, an MSA would be zero. Typically, we see for legal zeros to be supported, it should be a scenario where you've got the claim, but the claim is denied. There haven't been any payments made for medical or indemnity. If there are payments made, that's fine, but there needs to be some sort of state law confirming that either those investigational payments or those payments made in accident are okay, and that those payments in and of themselves won't force the carrier or the employer to hold the claim as compensable under state law. And then also it is necessary for the settlement agreement to not actually allocate for past or future medical amounts for that zero MSA to be supported. And we'll also get into this in later slides as well.
Perfect. Thanks, Brendan. Yeah, so my background, I didn't go into it in detail, but I was a litigator. I handled workers' compensation claims when I was first starting out in practice. I spent about 4 years doing that. And I used legal zeros and medical zeros as often as I could. They were pretty easy to come by back then. It's been probably about 15 years that I've been doing that. And Medicare, despite never really putting in writing what they were doing with approvals of these legal zeros, they did actually put in writing what they wanted with a medical zero, right? That's been in the reference guide. They want a letter from the treating physician indicating no future care, or ruling on the merits indicating no future care, right? We got it. Legal zeros were always kind of this fiction. You kind of heard about them. When you're first getting in the industry, you're like, well, wait, as a lawyer, you're looking at all the regs. You're like, where is this? It was nowhere in writing. And it basically said what Brendan, it was what Brendan said. Denied claim, no medical, no indemnity paid, and you could go ahead and get that $0 allocation. You could write an MSA, get it reviewed and approved. CMS's position was these were meant, the legal zero, with that denied payment history and all of that, they were really meant to be an exception to the rule. And what happened is they obviously became pretty popular. Denied claims aren't that uncommon in comp. In some jurisdictions, you have a pay without prejudice period where you can go ahead and investigate for maybe 60, 90, 120 days. Maybe you can pay up to $10,000 in some of these states, and then you can decide whether the claim is compensable or not. So folks did actually utilize this a lot. CMS just over time grew frustrated with it. The volume that they were seeing, they didn't really feel that it was a benefit to them. We really tried as an industry to argue why it was still a benefit. Hey, look, people are still using your voluntary submit program. But they were really frustrated with it. In the early fall of 2016, CMS, in fact, released an abrupt notice. So this was right as I was leaving private practice and kind of heading over here into this other world, the vendor compliance world. They released something abruptly, right? And they said, we're not going to review these anymore. See you later. Bye. If we advance to the next slide, about maybe a month or so later, on Halloween of 2016, they reversed course. The industry pushed back in full force. Probably, I know Heather blogged about this back in the day. I was blogging about this back in the day. Like, we were all over this because we had this process that was sort of extrajudicial, but we used it. And everybody who knew about it, this was part and parcel of your practice and how you were advising clients. So CMS backtracked. They said, hey, we recently received inquiries about this change in our process in reviewing $0 allocations, and these changes really transpired without us giving prior notifications to the community. And so given that, we're going to go back and we're going to utilize the policies and procedures that we had. So they just went back to status quo. They did make an attempt between 2017 and 2020-ish to kind of work with some of the industry groups like MSPN, which I think back at that time was NAMSAP, and they tried to look at phasing this out, and they really didn't like what the industry proposed, and so they backed off. But surprise, surprise, late last year, they started bringing this topic up again, and what they released in January is really what the industry was hoping for, that they would codify the rules around legal and medical zeros. So it's there. They're going to stop reviewing these allocations on July 17, 2025. But again, remember, these don't go away. These products are still available to you. And in fact, here at Sanderson Firm, I'm super excited about this because this is a product that I would have loved when I was in private practice. We are going to be offering a zero indemnified Medicare set aside. So we'll talk more about that, in the days and weeks to come, but please get in touch with us if you have any questions about it. These products are here to stay, and we firmly believe in them. If you have the basis for a medical or legal zero, we will stand behind that.
More to come on the zero indemnified MSA, but certainly the criteria around zeros are what Brendan went through earlier around legal and medical zeros. And so all of those scenarios would fit perfectly.
The other big piece of news is that immediate amended review that I already talked about. So it's available coming April 7th, 2025. You've got a one-time shot at this, and it has to be a workers' compensation claim that hasn't yet settled. And the projected change in the amount from the prior CMS approval has to be $10,000 or 10%, whichever is greater. This is great. Like I said, I really pushed at the agency on this one. I had a case that had been submitted where a woman had had a spinal cord stimulator trial. It was 50% effective at providing relief. She didn't want to go forward with full placement. The MSA got submitted before anyone realized it. That spinal cord stimulator, it was probably a 50-50 shot of whether it was going to go in. I would argue that, it might have been like, depending on which reviewer you get. CMS said, no, they all use the same criteria. But the reviewer that we had on that one ended up putting the spinal cord stimulator in, even though it was only 50% effective. Just like a month after they got that approval, they got a letter from the treating physician taking it completely off the table. And it was a bummer because she had to wait, and the parties had to wait an entire year before they could go for amended review and pull out this really costly procedure, right? Or they had to come up with some other way, some other outside the box way of solving that problem. So great news, starting right away after these approvals. If you're not happy with what you got, you get a one-time shot.
For sure. And I will add it to the extent that you all have some historical CMS determinations and you want to know, is this a good case for an amended review and you'd like to consult with us, we'd happily consult with you on that and determine whether we should pursue amended review, because like Annie said, you only get one bite at the apple. So we want to make sure it's the right bite and that you get the outcome that you want. So feel free to reach out, but now is really a great time. Wouldn't you agree, Annie, for, claims organizations to look back on these CMS determinations and perhaps pursue amended review and get these cases settled?
100%. And over here, you've got attorneys working on your cases. You have no development here. That's the other piece that's really important to think about. For those of you who do this, if you kind of forget to submit something with your initial submission, you can hit development and you can kind of come up with that item. If you're missing it, there's no shot for this. So over here, our legal experts are all over this. We make sure you have everything you need. We coach you every step of the way so that when we submit your amended review, you're going to hopefully get that approval with that lower amount or that changed amount that you're seeking. So yes, please get in touch.
Okay, well, let's shift gears and talk about the very important work comp MSA reporting that is going to be going live effective April 4th, 2025. So for those of you that are not familiar with this development, it came about just last year where Medicare said they were going to now mandate Medicare set-aside information on workers' compensation claims with Medicare beneficiaries that have a reportable TPOC, total payment obligation to claimant, right? A reportable settlement over $750. There's now going to be a mandatory MSA reporting requirement. So this is part of the Section 111 process. And yes, I'm sure you're wondering, if you sought CMS approval on the MSA, you still need to report this MSA information via Section 111. This is a mandatory requirement across both submitted MSAs and non-submitted MSAs. So it doesn't matter whether you've submitted the MSA to CMS for review. It doesn't matter if your total settlement amount is less than $25,000, which is CMS's threshold for review of MSAs. Even if ORM is denied or the claim is fully denied, these fields still need to be populated. Or even if you have a statement from the injured beneficiary's treating physician confirming that no future medical care is needed, you still need to populate this information. Even if the MSA is 0, it still needs to be populated. Okay, so here are the 7 fields that must be reported as of April. And I would say, really you should be, if you're not aware, if you're using a reporting agent or you're using a third-party administrator to do your Section 11 reporting and you have not been able to confirm that your reporting agent is ready and has added these fields, make sure that they've added these fields because, and we'll talk about it, I'm going to talk about it in a second, about how not having these fields ready to go in April and not populating these fields could cause some hefty civil money penalties. But first, let's talk about the 7 data fields that are going to be required. So first of all, Medicare wants to know the MSA amount, right? They want to know the period of time. How long is this MSA expected to last? Is it funded via a lump sum or an annuity structure? If it's an annuity structured MSA, they want to know the initial deposit amount. What is the annual deposit amount? If it was a submitted MSA and it has a case control number on that CMS determination, Medicare wants that submitted as well. And if there's a professional administrator on the MSA, they want to know the EIN of that professional administrator. So now let's talk about briefly the link between civil money penalties and failure to report these fields. So Medicare's rule on civil money penalties for non-timely or uncompliant Section 11 reporting doesn't speak to this specifically. But from a functional standpoint, and this is something that we've talked with CMS about and they have confirmed it, if you do not populate these 7 data fields, at least with zeros or with the information that is needed, it's going to cause what's called a hard error with CMS, meaning that Medicare has rejected the file and it's like you've never reported in the first place. And now you have an untimely situation in which you, the responsible reporting entity, could be subject to civil money penalties of up to $1,000 per day per claim adjusted for inflation. So this is significant. Make sure that you're ready to go and have these fields populated on every Medicare beneficiary settlement over $750 starting in April. Let us know if you have any questions, but again, make sure that you're ready to go with this. This is really important. So again, this only applies to Medicare beneficiaries, right? Because Section 111 is only for current Medicare beneficiaries. You might be providing for Medicare set-asides on individuals that have a reasonable expectation of Medicare entitlement within the next 30 months, or you might have it on someone that's 62 and a half years of age or older, right? Those are still appropriate MSAs to have, but they're not going to be reportable because Section 111 is only pertaining to current Medicare beneficiaries. This does not apply to liability or no-fault claims, right? This is just for workers' compensation. We'll see in the future if this does end up applying to liability. Medicare has gone back and forth on wanting to take a position on liability MSAs over the years. They still have not taken a formal position or they're not reviewing them, so those are not reportable at this point in time. Definitely would not take this new reporting requirement to mean that this is a way for Medicare to attack non-submit evidence-based MSAs. There might be some suspicion out there, but Medicare was very transparent about the purpose behind this MSA reporting. And I even asked when Medicare had a webinar, when they first introduced this concept, I typed in the question, why does Medicare need MSAs reported via Section 11 in which they've reviewed the MSA already and issued a determination? And what Medicare said was that a lot of times post-settlement, even they would know perhaps via the Section 111 that a settlement occurred, but they might have approved an MSA, but they didn't get a copy of the finalized settlement documents post-settlement, so they weren't always kept in the loop as to when these MSAs were being funded. So this now allows Medicare to know when MSAs are being funded, both submitted and not submitted. And the entire purpose behind the reporting is so that Medicare can coordinate benefits. So let me give an example. Let's say you have a Medicare beneficiary workers' comp injury and the person has an injury to their right shoulder. The parties look to settle the claim and there's an MSA amount of, let's say, $20,000. And so this is a reportable situation. And now the responsible reporting entity would report that right shoulder, that settlement of $20,000 with the right shoulder ICD codes. Medicare would know, and they would know that there's an MSA. Let's say it was $3,000, right? Now, let's say inadvertently the Medicare beneficiary goes and treats for that right shoulder and they send that bill to Medicare on accident or inadvertently. Medicare would then stop payment for that because they're now aware there's an MSA available to pay for that treatment, and they would say you need to bill the MSA. So that's the whole purpose behind this, so Medicare can properly coordinate benefits and not pay for care where there's an MSA available. So that is the intent behind it. Medicare was a little bit threatening about their seriousness behind this MSA reporting requirement. And they said on the webinar that any RRE, any responsible reporting entity that knowingly reports false MSA information will face legal action from CMS, including False Claims Act litigation, which we all know can involve triple damages. So this is serious stuff. Very much want to make sure everyone appreciates the importance of this development. So long story short, some best practice. If you are obtaining and funding MSAs correctly, You shouldn't change anything that you're doing with regard to your MSA practices, right? If you're a fan of non-submits, that's fine. Keep going with those. If you prefer submission, keep going with that, right? Because again, as I mentioned, the sole purpose behind this MSA reporting is so that Medicare can coordinate benefits. Should you care more now about having an MSA in under threshold situations, right? So we know Medicare's threshold for review of MSAs with Medicare beneficiaries is $25,000. There are other criteria for reviewing an MSA is a reasonable expectation person and a settlement over 250,000, right? So you might be wondering, should we now be doing MSAs on under threshold settlements? Yes, Medicare is going to see that these settlements are occurring with Medicare beneficiaries, and Medicare has always said that their voluntary workload review thresholds are not a safe harbor. They've always said this, and so in that regard, nothing has changed. We've always advised, I've always taken the position that, and Medicare has as well, that their thresholds are just that. They're voluntary workload thresholds. They have never indicated when you should obtain an MSA or not. So I would actually be looking at these under threshold situations. If there is a need for future medical care, you should consider an MSA. And again, as I mentioned and really emphasized earlier, make sure that your reporting agent or your TPA or however you're doing your reporting has these 7 data fields ready. I have heard of numerous claim systems and several reporting agents that have not had these 7 data fields put into their system yet, and that is extremely troubling. Indeed, Medicare did give a short time frame on this reporting requirement for systems to be ready for this, but you need to be ready because, as I mentioned earlier, there are significant penalties that can be imposed if this does not occur. So more to come on that as we progress throughout the year. We will certainly provide more updates as the MSA reporting goes on. Annie, let me turn it over to you.
Yeah, so one of the questions we get asked around this reporting piece, right, is, could CMS use this to audit you, comment and check on the adequacy of what you put in there for future medicals? Because they didn't used to ask you for this information, right? Anything you settled, really, you just sent in the TPOC when you were required to, and that was it. That was your total payment obligation to the claimant, your settlement amount. They now want to know how much of that settlement is for future care. So what we wanted to do is, in answering that question, just give a little bit of background about how we got to where we are and how CMS can act. So one of the things we always go back to is the 2001 Patel memo. That sort of, gave rise to kind of where we are today. And now in today's world, we have the reference guide. But one of the areas where we sort of get into it with Medicare a lot is around commutation and compromise. And if you read the original Patel memo, I have an excerpt in here, he's going on and he's laying out this idea that future care allocations that are funded happen only in workers' compensation cases that possess a commutation aspect. They're commuting benefits, right? It's an admitted claim. That person is entitled to some amount of benefits, whether those be indemnity benefits and future medical benefits or additional benefits, right? And so if you want to settle with that person, you're going to commute those future medical benefits. That's why they came up with their voluntary review program. You can participate in that and kind of have them double check and see if you're kind of commuting those benefits properly. So what is commutation? Commutation is exactly what I just said it was. It's taking the benefits that you think are due and owed and calculating that out. So in our MSA world, that's cost projections, right? Looking at the care, looking at the treatment, looking at the DME, and figuring out what the future medical piece looks like. Compromise here, the way that I believe Patel was talking about it, is really this idea of what happens in denied workers' compensation cases. When I was a litigator, this is exactly how we looked at them. We're not commuting any benefits. We denied the claim. We have got a good faith basis for that denial. We haven't paid anything in medical. We haven't paid anything in indemnity. We're going to go ahead and compromise. We're going to do what happens in liability all the time. We're going to have an arm's length transaction that says, hey, you think something happened that we're responsible for? We don't think we're responsible for it. We're going to buy our piece. We're going to hand you a bag of money and you'll be on your way. No commutation of benefits. There isn't money being paid for future care. There's money being paid to buy your piece. So in the CMS context, I think Patel was on the same page with the regulated community. CMS, though, in its later iterations, really looks to a definition of compromise that they find in regulations. And it really gets to whether or not they can compromise with the parties on not fully funding the future care, like the commutation aspect, right? And so, particularly with John Jenkins in that role, there was a lot of back and forth. So just know that there's kind of been this back and forth piece that kind of underlines everything that we do. And particularly that compromise piece comes into effect with the legal zeros. So what we need to do is we have to reasonably recognize Medicare's future interest. We've done that by voluntarily participating in their review process. But as you go through that, as you see through the years, the process kind of gets more and more onerous. And there starts to be issues with CMS's definition of compromise. You're probably a big fan of our non-submits. You utilize them because you see that there are some of these problems inherent when submitting. But of course, if you're more traditional and you like that submit process, like Heather said, you're going to keep doing it. But please know that there are going to be spots where the rubber doesn't meet the road, where they're just not going to acknowledge that state law, or you're going to have to jump through a hoop and get a ruling indicating the state law applies. So there are some issues with that reasonable recognition, right? You're using AWP, which some people say ain't what's paid. I think Mark Pugh out there says that. Duplicative therapy, right? If you're on opioids, the doctor then just recommends that this individual undergo a spinal cord stimulator trial. If you submit that MSA as is, opioids are going in, plus that, psych eval, that trial, the actual implantation, all of the reprogramming, all of that. So you start to see these issues. I won't walk through all of these, but that's really our goal, right, is that reasonable recognition. So if we move to the next slide, we can sort of see why non-submits came to be, right? CMS already gatekeeps what they'll look at because Heather talked about it. They have workload review thresholds, right? They have reasonable expectation cases, and you have cases with beneficiaries that are under $25,000. They now want us to report on those, right? So those of you who might have had a program, we always used to say it's not a safe harbor, but there were plenty of folks out there using the workload review threshold as a safe harbor. This reporting requirement in April is really doing away with that. So non-submits are a perfect thing to slot in there, right? It gives you the ability to accurately account for what's been pled, what's being released. You could maybe avoid overfunding by using pricing that might be better than the AWP. Maybe AWP is the lowest, but let's take a look around. Are they going to use a PBM when they're done? And then, of course, there's indemnification available here. So for those of you who want that extra security, it's there. So that's really why we see the rise of the non-submits. And they're a great thing to slot into, to help you with this reporting.
Thank you, Annie. So just a little bit more on the history of non-submit MSA. So we are 2 years, actually, no, I guess 3 years now. Time flies. 3 years removed from when CMS first addressed evidence-based MSAs and the practice of obtaining a Medicare set-aside and not submitting that Medicare set-aside to CMS, even though that MSA would have met CMS submission thresholds. So some of you may remember January 2022, CMS for the first time in writing addressed these evidence-based non-submit MSAs, and CMS inserted language straight into their policy reference guide, the WCMSA reference guide, where CMS said, quote, or essentially, if you have a non-submit evidence-based MSA, CMS will, quote, deny payment for medical services related to the workers' compensation injuries, essentially because CMS could not guarantee that the proposed amount was actually protective of Medicare's future interests. And of course, that caused a huge flurry, outrage in the industry. And so a month later, CMS said, okay, let's open this up for industry feedback. So a town hall webinar was hosted by CMS in February of 2022. And I think CMS at that time, they must have realized their error and realized that they could even face legal challenges for their very unsupported, aggressive policy position on evidence-based non-submit MSAs. And so CMS walked back their language. They changed that mandatory will language to the discretionary may language. So CMS updated the language to say, quote, CMS may, at its sole discretion, deny payment for medical services, right? But CMS could only do this if, one, the amount of the Medicare set-aside itself was not supported, was just simply inadequate, and two, if the MSA funds were improperly used. But outside of those parameters, CMS is not was not was not has not will not challenge a non-submit evidence-based MSA.
Well, we get this question a lot. What if Medicare was to challenge a non-submit allocation? So first of all, I want to kind of take a look at what the law says. So uh, there are a set of regulations that pertain to the MSP Act and also pertain to lump sum settlements. And so specifically putting here on the screen is 42 CFR 411.46D. I'm not going to get into too much of the legalese, but I do want to specifically point your eyes to subsection 2 exception, which notes that if the settlement has a specific carve out for specific future medical services, Medicare will respect that aspect of the settlement allocation, and Medicare can only deny treatment for the rest of the settlement. So let me explain this in simple terms. So let's assume you have a settlement of $100,000 and a $20,000 non-submit MSA. What Medicare was saying in their original January of 2022 update to the reference guide was they were just going to deny the whole settlement for future medical care up to the $100,000, and we're not going to regard that $20,000 future medical carve out. And I was on the phone with CMS multiple times. I know, I'm sure Annie, you were too in your previous rule when Medicare came out with that wrongful guidance saying, hey, CMS, you are disregarding a clear part of the law which says that Medicare has to recognize the specific carve out for medical, and it's all laid out in 42411.46D2. If Medicare has an issue with this, they need to change the law. Unless and until then, they cannot. And I will state, for those of you that are not aware of this, the actual terminology Medicare set aside does not exist within the MSP Act at all. In fact, the origination and the recommendation for MSAs actually came out of this exact statute. And that's why MSAs are a best practice in settlements with Medicare beneficiaries and reasonably expected Medicare beneficiaries. But technically, Medicare cannot require you to submit an MSA to CMS. Technically, MSAs are a best practice and not required in the first place. So let's imagine you're thinking about working with a non-submit MSA and you've not had familiarity with that before, and maybe you're a little uncomfortable and you're wondering, what is the risk here? Is CMS going to challenge our non-submit MSA? And so first of all, I want to mention that we're pretty well connected in the industry here, and I could say I've never heard of Medicare challenging a non-submit MSA to date. As Brendan mentioned, we're 3 years removed now from that section being added to the reference guide, and we know, and as Annie mentioned, it seemed like Medicare knows they completely overstepped. But let's say at some point in the future that Medicare does challenge a non-submit MSA. So first of all, a couple of things have to happen. First of all, the Medicare beneficiary or injured worker needs to fully exhaust their MSA. And we know if you work in work comp claims, a lot of times treatment drops off post-settlement. It's very rare for an individual to fully exhaust their MSA. Let's say that it does happen. They fully exhaust their MSA, and then a bill is then submitted to Medicare, in which Medicare perhaps denies payment for that care because Medicare takes the position that the MSA was inadequate. So Medicare would then presumably be able to challenge the non-submit MSA through their administrative appeals process, but there would be due process. They can't just say the MSA was inadequate without providing the parties full due process, which here at Sanderson Firm, we are ready for that should that day ever come. On all of our non-submit MSAs, we have intense clinical documentation, legal documentation on every single MSA we produce so that we stand ready should CMS ever challenge our MSA, that we are fully ready to back that MSA. So Medicare can't just arbitrarily deny your non-submit MSA. So I want to make sure that everyone is aware of that. And again, MSAs are voluntary. So how Medicare would ever pose a legal challenge for something that is a voluntary best practice seems clearly remote and unlikely. So we feel very strongly about that. And I will say that non-submit MSAs, without going into too much detail, for those of you that are not familiar, generally you're going to see significant cost savings with the evidence-based medicine being applied and a more reasonable approach to the allocation. Okay, civil money penalties. Brendan.
All right, everyone. So civil money penalties, aka CMPs. So hopefully, as most of you know, this civil money penalties went live October 11th of last year. So we're fresh into this. And civil money penalties, of course, penalize responsible reporting entities for improper Section 111 reporting practices, specifically timeliness, untimely reporting of the TPOC, that is essentially untimely reporting of a settlement involving a Medicare beneficiary, and also the untimely reporting of the acceptance of ORM, ongoing responsibility for medical. So specifically, if you are an RRE as an organization and it takes you longer than 1 year to report the TPOC or to report the acceptance of the ORM, you are going to be subject to an audit. And if you're selected during the audit and Medicare sees the non-compliance, you will be penalized based upon the length of your non-compliance. So if it takes you in between it takes you longer than a year to report either the ORM or the acceptance of the ORM or the TPOC, but less than 2 years, there is a daily penalty of $250 per day. If it takes you more than 2 years to report, but you report within 3 years, there's a daily penalty of $500 per day. If it takes you longer than 3 years altogether, the daily penalty for that is going to be $1,000 per day, which is capped at $365,000, but that does not even account for inflation. And so realistically, you're looking at $500,000 just for improperly reporting one record, an ORM or a TPOC. So a quick reminder too as to how crazy this can really get. So remember, we were talking about Section 111 and civil money penalties. We're talking about Medicare beneficiaries. And some of you may think that, okay, this only applies to one Medicare beneficiary, and just a single Medicare beneficiary is just one record. That's not the case. A single Medicare beneficiary could be as much as 2 records, because you could have a TPOC record, right? A Medicare beneficiary could receive $100,000 settlement, but there could also be an ORM record, right? Assuming it's a work comp claim and the claim was accepted, Medicare wants to know whether that ORM flag was marked yes or no. And if it's accepted, right, it falls under the CMP window. So as an example, you have an RRE who settles an accepted workers' compensation claim with a Medicare beneficiary. This RRE fails to report the TPOC in the ORM timely, and for whatever reason, they'll get to it later. They report it 3 years after the fact on both instances. CMS's audit may randomly select that beneficiary's TPOC record in their ORM record, right? So the CMPs are effectively doubled. So $365,000 times 2 is $730,000, but as adjusted for inflation, your failure to report on just one Medicare beneficiary could be over $1 million in civil money penalties. So that's why timely reporting is incredibly important.
Hey, Brendan, I just wanted to share something there too. So yes, that's very scary, but statistically, that is very unlikely to happen. And one of the things you should keep in mind is CMS is going to be auditing 250 records per quarter across NGHP. So that's across NGHP and the GHP world. So the chances of you getting one of your records selected, let alone a record selected for both, is pretty slim. And they have said, like, if they grabbed the Annie Davidson record and you were late on TPOC, but they grabbed it to audit it for ORM and you were timely on ORM, you don't get hit with that penalty on the late Annie Davidson TPOC. You sail through with the timely ORM. So, the sky isn't falling, but certainly keep an eye on this. So just wanted to add that context, Brendan.
Perfect. Yeah, we've got the two extremes there. Thank you for adding that, Annie. So best practices on CMPs. So one, you want to report your ORM and your TPOC timely as soon as possible. Obviously, you have the 1 year grace period, but maybe it makes sense if you are self-reporting these claims, consider setting up your system in a way that there's an internal failsafe. So there's a flag if maybe there's a TPOC that occurred and you don't get around to settling it, 30 days or 60 days. Maybe have a quick reminder just to alert you that, hey, this needs to be reported to save yourself some grief in 1 or 2 years. If you're not self-reporting, consider using a more consultative reporting agent, like a Sanderson firm, for example. We do reporting for some of our clients. Because remember, if you have a reporting agent who doesn't know what they're doing, right? It's strict liability. So CMS will hold you as the RRE responsible for the improper reporting, and they won't seek that CMP recovery against your reporting agent. Secondly, also consider obtaining an objective third-party Section 111 data audit to identify weak spots in your data. That is a service that we, Sanderson Firm, do and that we do regularly. So we will identify weak spots, have a call with you after the fact to explain, how you can tighten things up. So consider that as an option. And then lastly, a question comes up: should responsible reporting entities report older claims which were never reported? So obviously, if it's a claim where the acceptance of the ORM or the TPOC were dated prior to October 11th of 2024, then technically these would not fall within civil money penalty exposure. But if you have old data that was reported to CMS and it hasn't been updated, that could cause some coordination of benefit issues for the beneficiary. Just remember, we're talking about data and we're talking about this in the abstract, but there's a person attached to the end of that record. And so last thing you want is, Sally Mae to go to their doctor and have Medicare deny benefits just because there was a reporting issue. And then last thing to note, we have been asked this question is, okay, can we just never report either the ORM or the TPOC to Medicare and never face CMPs? Like, how is Medicare going to know? Medicare doesn't get all of their data just strictly from the Section 111 reporting feed. They do have ways of discovering whether a claim actually exists. One way, for example, is if a Medicare beneficiary goes to their doctor, their treating provider, and they mention on their visit, I hurt my arm in this work comp claim, right? That's something that the physician is probably going to report to Medicare. And even though the RRE didn't put Medicare on notice, Medicare is now officially on notice, and that RRE could face some potential CMPs there if it's not properly or timely reported.
Great. So I want to let everyone know we've already set the date for our next webinar. It's going to be March 12th at 1:30 Eastern Standard Time. We are planning a robust webinar schedule for this year. We're going to be doing a webinar nearly every single month. We want to encourage all of you to email spotlight@sandersoncomp.com if you'd like to be automatically enrolled for all Sanderson Firm webinars coming up in the future. Now, I don't want you to think that means you need to be in front of your computer or available every single time we have a webinar going in the future. It would automatically enroll you, but then it would make sure if you can't make the webinar on that date and time that you get a copy of the PowerPoint as well as the recording link so you can watch that future webinar at your leisure. So we encourage you. Also, part of the survey will ask you if you'd like to be automatically enrolled. So if you check yes on that, we'll make sure that you get a link to the recording. I just want to briefly touch on the fact that Sanderson Firm is a nationwide MSP service provider. Our specialty is across Medicare set-asides, all types, from traditional work comp MSAs to indemnified non-submit MSAs. We also have a up-and-coming, as we mentioned, zero indemnified MSA. We do Medicare conditional payments as well, identification, resolution, and disputes. We also are a Section 111 reporting agent to Medicare, and we also do, as Brendan mentioned, Section 111 audits for entities, and that's something that's been requested more frequently there, and highly encourage you to utilize that if you're not sure about the health of your Section 111 program. And because we are a law firm, and just here on the webinar, you've got a couple of our Sanderson Firm attorneys, but we have more on staff. So you have the option to also utilize us for our legal services, such as MSP opinion letters, guidance, best practice improvement, or if you're looking for training for your teams, that's something that we're available for as well. I just want to briefly touch upon MSP College. This is an educational platform that we launched last year. It provides 2 educational certifications in MSP. We released last February the Medicare Secondary Payer Accreditation, MSPA for short. It's comprised of 9 courses that cover MSAs, conditional payments, and Section 111. The beautiful part about this program is that once you sign up online, you can start and stop as much as you'd like. You can take it at your own leisure. When you complete the program, there's going to be a test at the end, and you will receive a certificate, an MSPA PIN. You will receive access to the faculty at all times, and then we will continue to put out content and have continuous recertification on this program. We've had a good number of registrants in just a year on this program and great feedback on it. So if you have more questions, please reach out. And the other educational program we launched through MSP College is known as the Medicare Set Aside Certified Planner, which is MSACP for short. It's in approximately 11 modules geared toward the fundamentals and development of a workers' compensation MSA. And upon completion of the course, you'll be equipped to write an MSA, allocate an MSA. You don't actually have to write an MSA in the course, but it will teach you how to do so. And again, this is also completely at your own pace. So if you visit www.mspcollege.com, you can find out more about those educational certifications. I want to make sure everyone is aware that mine and Annie and Brendan's email addresses are here on the screen. We've also listed our office phone number should you need to call and have any questions. And also, please feel free to visit our website at sandersoncomp.com. Also, lastly, if you somehow got on today's webinar, but you're not receiving our emails with notifications about MSP developments and blogs and webinars, please go on and sign up at the contact and subscribe button on our website, and you will be linked into all future communications. We just have, outside of asking whether the PowerPoint and webinar recording would be available, I only see one other question, which is perfect because we're right at time. The question is, the list of new fields indicates that the last two fields for MSA reporting are optional. May we omit those without negative consequences so that it wouldn't cause a hard error? Is that correct, Annie? You're shaking your head, yes.
Let me step in here.
Absolutely.
I think that's a great question. I think that's an excellent question. I think it's a bit of a trick question. So Niall Regain. So in Medicare's webinar, when they hosted the conference on this, they had a PowerPoint. In the PowerPoint, they listed those last two fields, the professional administrator and the work comp case control number, as optional. If you go in their actual published notice, and I can send you this link, Niall, if you ask for it, but those fields actually do have to be populated either with zeros or with spaces. So you can't leave them entirely blank. You have to put in some value in there, or else it'll cause the record to get rejected.
Great question.
That's exactly it. Yep. I love the clarification. You have to put something in there just indicating that you're not doing it. But yeah, it's optional information. And my advice typically with anything optional with CMS is don't give it, but comply with the whatever they're telling you to put in for the coding, like Brendan said.
Perfect. Well, we are at the hour, top of the hour. I want to thank everyone for joining today. Please reach out if you have any additional questions, and we look forward to seeing you all in the next webinar on March 12th. Brendan and Annie, thank you for being my co-panelists today. It was a pleasure. And again, thank you for everyone for joining, and we will be sending out the recording and PowerPoint shortly. Thank you, everyone.
Thanks, everyone.
Bye.
Bye, everyone.